Hello and welcome to Rights and Recourse, a program that educates you about your rights and recourse to those violated. My name is Dumilo Matez. The Constitution of the Republic of South Africa provides that everyone who is detained, including every sentenced prisoner, has the right to choose and to consult with a legal practitioner, and to be informed of this right promptly. Such a right does include a legal practitioner assigned to the detained person by the state at its expense, especially if injustice would otherwise result. It is mandated that the detainees should be given a reasonable opportunity to obtain the services of counsel, for example, by authorities, allowing the detainee to contact a relative, the legal aid board, or a lawyer. This reality came to a head at an international conference held in Johannesburg, South Africa in June of this year. This is Rights and Recourse. The Honourable Minister of Justice and Correctional Services, Mr. Michael Masuta, opened the international conference themed Access to Affordable Legal Aid in Criminal Justice Systems. Let us listen in on his opening remarks.
Our Constitution is premised on certain values and principles. Many of these principles are outlined in a part of that Constitution that's referred to as the Bill of Rights, and the right to legal representation, especially of accused persons appearing before courts, has been specifically dealt with and emphasized. To make that right a reality, the state is enjoined to make all the necessary institutional arrangements and provide the necessary resources so as to ensure that every person gets a fair trial, by, amongst other things, ensuring that despite their economic situation, as I said, have access to legal representation. And this is a critical value that underpins one of our fundamental rights in our Constitution. And that is the right of access to justice. So the discussion that you're going to be engaged in the next few days is not a small matter. And therefore, the trouble you have taken to come together to share ideas and experiences from different parts of the world, to reflect on the state of human rights more broadly in the world, but in particular as relates access to justice, is not only a laudable one, but a very necessary one. We read every day in the media of many instances of human rights abuses, be it perpetrated by state apparatus in different parts of the world, or instances where it appears that the state is not able to respond effectively to the rescue of those that fall victim to human rights abuses. Our legal system is there for the underdog, and for those that are disadvantaged in different ways, those that are vulnerable, be they women, children, people with disabilities, and others, gay and lesbian, members of the community, etc. For them to have access to services that institutions such as Legal Aid South Africa provide is not a privilege. It's one of those fundamental support systems that make a difference in them being able to say that they too are able to enjoy the same rights as everybody else under the Constitution. I have thought that instead of reading out this 26-page speech that will make me miss my flight, I should rather use the opportunity to assist Justice Mlambo in welcoming you to South Africa and telling you that, yes, you have arrived in the middle of our winter, although people who come from the extreme northern part of the world might find this feeling like summer, and to say, enjoy our African sun. You would have enjoyed a lot more of it if you came in December, if you can take the heat. But the bit that is there, enjoy it. Enjoy the hospitality, the warmth. We have a culture we call Ubuntu, which is the way in which we express our humanity and extend our warmth and friendship, especially to our own guests. We believe that your gracing our land with your presence will help strengthen our quest as a nation to reinforce a culture of human rights. We've had our own challenges. We've had a bit of a tint of xenophobia at a certain point, which hopefully we were able to bring under control. We've had challenges of women being subjected to all forms of violence and abuse, and hence we have strengthened our justice system in ensuring that there are special courts that are there to protect women, to protect children, and other vulnerable groups. I think that in your deliberations, you will not only confine yourself on issues of legal representation, but will seek to add a voice in this advocacy towards the development of a human rights culture in the world, where every citizen of the world will feel that anywhere in the world where they are treated as human like everybody else. And on those few words, I wish you well in your deliberations. I thank you.
The Honourable Justice Dunstan Mlambo, Judge President of the Gauteng Division of the High Court of South Africa and Chairperson of Legal Aid South Africa, in his welcome address, shared with us the importance of affordable legal aid. Mr. Judge President, how important is legal aid?
It is very important because we have a lot of people who are poor and vulnerable, who are in conflict with the law, but who have not means of their own to access the justice system. So through legal aid, they are able to receive fair, quality and justice.
Why was it necessary for you to convene this international conference?
It's because this country piloted the United Nations principles and guidelines on access to legal aid in criminal justice systems. And our objective is to ensure that that document becomes a living reality, in the sense that through this conference, we hope to come out with realistic outcomes and action plans to ensure that we address this problem, which is global.
Many people say there's a dichotomy here. You have people who have criminal acts, and yet the state must provide the money to defend them.
Yes, but there's a presumption that one is innocent before it's found guilty by a court of law. And before you can be found guilty or declared innocent, you've got to receive quality legal representation to ensure that the court that hears your matter arrives at a just decision.
You have a wide array of countries that are represented here at this conference, and some of them have been there's been strife in their parts of the world. You're hoping to influence those judicial systems to be able to follow in the footsteps of many people who are doing, many other countries that are doing well, and the United Nations principles.
Indeed, those are the post-conflict countries that we've targeted because legal aid schemes or institutions are non-existent in those countries. So we hope to assist those countries to establish their own legal aid institutions because many of their people go through court systems without being represented. We also have countries that have some rudimentary legal aid schemes, and we hope we'll be sharing good practice and experiences, especially as we have in this country, as to how they can go about ensuring that they reach a sustainable level at dealing with the demand for legal aid services by poor and vulnerable people.
We also understand that legal aid is not only confined to paying for legal fees, also pays for bail.
Legal aid doesn't pay for bail. We represent people in bail applications, but if they are granted bail, that person must pay the bail that is set by the court. But our involvement in those proceedings is to ensure that the proper and reasonable bail amount is set by the court to ensure that the person, no matter how poor he is able to raise that amount. Because as we sit here today, there are many people who've got minimal bail amounts, but who can't raise them. But we also have a good chunk of people who are sitting there because courts have issued unreasonably high bail amounts, and that's one of the areas that Legal Aid South Africa lawyers argue against daily when they appear in court.
It's been said in many sectors that the Illegal Aid South Africa has not been able to attract good lawyers who can defend people in court, and it's just because of budgetary constraints.
That remains a perception. The Legal Aid of South Africa, or that we have today, has a budget that attracts suitably experienced and qualified lawyers, people who've been in practice for some time. Especially if we're going to deploy you in the regional court, we don't take first-time lawyers. We take people who've been in practice for some time. Usually it's not less than 5 years in practice. And in the High Court, where we've got High Court units, we employ people who've got more than 10 years practical experience practicing law to ensure that they deliver quality legal representation to the people that come to us for assistance.
What are the issues that are going to be deliberated on over the next 2 days at this conference?
The biggest one is that Legal Aid South Africa has supported many countries who've come here to observe what we do. And there's one thread that runs through most of them, is that they don't have enabling legislation in their countries that enable them to establish legal aid schemes like we have in this country. And as a result, ministries of justice do not prioritize funding for legal aid schemes in those countries. So we hope to address that. That's why you may have noticed that we have a lot of ministers of justice and deputy ministers of justice for them to come and learn how it should be done to make sure that there's a sustainable legal aid scheme in each of those countries.
It would seem to me that South Africa is used as an example throughout the world in this kind of defense system.
It is indeed, because we are a developing country, but we have one of the most sophisticated legal aid schemes you can find, even in the developing world, because of how we've approached it and because of the maturity shown by the executive in this country in terms of ensuring a continued funding model for Legal Aid South Africa and not to interfere in what we do. So a lot of countries come to us, they approach us, they invite us to come and talk to them because of what we've achieved. And all of it is because we've got legislation in this country, all rooted in the Constitution, that anyone who appears in court and who hasn't got means must be provided legal representation at state expense.
There is something fundamental about the legal aid in South Africa, and that you're collaborating with the universities like Witwatersrand and Pretoria University, and that should be helping you in holding you in good stead.
Indeed, we have a lot of cooperation agreements that we sign with university law clinics. You've mentioned one. There are others like the University of Pretoria, where lawyers who are employed by those universities who run legal aid clinics and who provide an access to people who live in those areas to approach them. So we sign cooperation agreements where we fund their activities to ensure that they continue with their work.
How does the man in the street know about the services that are offered by Legal Aid South Africa?
On an annual basis, Legal Aid issues pamphlets. I think in the past 3 or so years, every year we've issued more than 6 million pamphlets in different languages in South Africa, just to inform people of the availability of legal aid services at state expense should they not have that. We also try and get slots in radio stations as well as in TV programs to make sure that people listen to us. Our people talk a lot on the vernacular radio stations because the majority of people who want to access our services live in the townships and they don't subscribe to the sophisticated channels. So if you speak to them in their vernacular radio stations, we are able to reach them. And we also have a legal aid advice line that people should know of, where they can phone from wherever it is toll-free should they have any particular problems.
Mr. Judge President, we'll be talking and following the discussions here, the deliberations at this conference over the next 2 days. Thank you very much for your time and good luck with the conference.
Thank you very much for talking to me.
Share your views and comments with us on Twitter at Recourse or hashtag SABC News Online. Stay with us.
Technology is all around us and is improving lives across Africa, like how young Nigerians are connecting to the internet. There are doctors finding new ways to save lives in Cameroon, and the South African public transport system that is now getting Wi-Fi. We have gadgets, apps and loads more, some of which play a big role in Africa's growth. A huge part of this African growth is technological innovation. To find out a bit more about social media and technology news from here in Africa and abroad, join me, Siphumelele Zondi, every Sunday at 7:30 p.m. on SABC News.
Welcome back. The Chief Justice of the Republic of South Africa and the President of the Constitutional Court, Justice Mogoeng, gave the keynote address at the conference, and here is an excerpt of his address.
Here to discuss one of the fundamental human rights within the criminal justice system, and that is indigent persons' access to legal aid when accused of having committed crime. And maybe due to time constraints, I should deviate a bit from my paper. It can always be circulated. I think the good starting point is to reconnect with reality. And the reality in governance circles is the following. Matters that affect the court system generally are not prioritized as much as they should. Look at the budgets, be it the budgets of the executive, the budget of parliament, and compare them to the budget of the third arm of the state, the judiciary. And that tend to explain why issues like providing meaningful legal aid to the multitudes that we know do not have the means to pay for legal representation do not enjoy as much support and priority as they ought to. I'm happy that we have honorable ministers of justice from some of our countries present here. I think it is a good starting point to begin to talk about this issue. I've had occasion to raise it in our own country, but also went further to say, even if you look at the regional structures that have a say in matters that affect the running of the courts and whether or not the courts enjoy the kind of support that they ought to enjoy, you will find that judicial officers do not have any role to write home about to play. The SADC Tribunal, in its establishment, where judicial officers ever consulted, in reducing the role that it has to play, in ensuring that SADC is a much better place for the inhabitants of the region, were members of the judiciary consulted? Was the legal fraternity consulted? And don't you think the situation would have been much better had those who have a crucial role to play in the protection of the fundamental rights of the inhabitants of various countries and regions were afforded some space based on their experience and wisdom gathered over the years as a result of the day-to-day participation and experience of what the underprivileged are going through. Don't you think the situation would have been different? We can never be heard to say we are committed to the human rights culture as governments for as long as the fundamental right to be legally represented is enjoyed even by the poor. And by legal representation, of course, it's not just a question of having a legally qualified person standing next to you. It is the quality of the legal representation that is important. You've got to make sure, as a government, as the state, that the budget is such that those who serve in these structures on a permanent basis are properly trained. There is scope for upward mobility, some career pathing possibilities exists, because then they will stay. But if they are paid a pittance, you're going to have a serious problem attracting people who are sufficiently skilled to do justice to the cases of the people they represent. You're probably going to find or attract people who don't even have confidence in themselves, so much so that they will be just too happy to settle for a plea in circumstances where an accused person has a strong case. So the ability to attract properly qualified and well-skilled lawyers is one of the issues, but also the ability to train them and train them well. It's important to look into who trains these people. What does he or she have? What experience do those who train these lawyers have? And then, of course, you'll be able to retain them, as I alluded to this factor earlier on, if you pay them fairly well. But also the tariff for those practitioners who are not in-house legal representatives employed by legal aid. The tariff determines whether or not you will continue to enjoy the services from these people and the level of seniority, the level of ability as well. Because the less you are prepared to pay, and we know there are financial constraints, determines the quality that you will be able to attract.
Brian Nair, the National Operations Executive for Legal Aid South Africa, gave the rationale and objectives for the conference, which is, amongst others, to encourage productive dialogue, discussion of good practice, and action-oriented outcomes.
Dumilo, it takes months of planning obviously at the early stage of preparations, you need to know what you want as outcomes of a conference like this, and that then dictates the content for the program. So months of preparation went into thinking around what would be the deliverables you want to get, thinking about the programs, who would be the expert speakers that can actually add valuable input so that lessons can be learned. Then obviously we're dealing with a conference that has multiple hosts. It would have been easy if there was only one host because only one decision maker. But here in this case we had 5 co-hosts and 3 of them were international. So it was a matter of getting 5 groupings together on a continuing basis to make decisions. So that was obviously a challenge, as well as it was going to be an international conference with a focus on African countries. So it was about identifying the suitable role players in the different countries that can actually benefit from a conference like this. We didn't want to attract the developed countries that have got developed legal aid system because then there was no value in that. It was about getting countries who were developing systems or don't have any legal aid systems at all, who we felt could actually benefit from this. And I'm pleased to say, Dumela, we had 67 countries represented at this conference, over 250 delegates. So that objective was achieved, and we're hoping that at the end of this conference, everyone would have left with important lessons learned, and they would be able to actually implement many of the thinkings that came out of this conference.
What are the themes of the conference, the major themes?
The big focus of the conference was obviously the UN principles and guidelines. It's a resolution by the United Nations that South Africa played a leading role in championing and getting it adopted by the United Nations. But like resolutions, it can be adopted and it may not be implemented. So the idea was, if we played this major role in getting it adopted, how do we make sure that the next steps of implementations takes place? So the big focus around all the themes that took place in this conference was how do we implement the UN principles and guidelines. So it dealt with talking about demand. What is the demand for criminal legal aid, and how do you satisfy the demand? We dealt with what do you mean by quality legal aid services, so that people, indigent people, can have some meaningful representation. We dealt with issues such as access. How do you provide early access to criminal legal aid services? So those were all the themes, but it all revolved around giving input and effect to the principles and guidelines.
Share your views and comments with us on Twitter at Recourse or hashtag SABC News Online. Stay with us.
I once saw a flower blossom through 27 prison bars of yesterday's unjust flames. I felt an old woman's anticipation for the country's first open elections. And I heard the loud celebrations of that flower's historic inauguration. I was there when Unity sang of how the Springbok never held anything back, and we saw a first-time band of 11 men, Shibobo possibility throughout the land. At the foot of Africa, time remembers how truth can reconcile a people. We carved our name into space, and on the world stage, our art stood united. When we blow that vuvuzela, the whole world goes into a trance. And even in that tearful hour of the flower's separation, we are a people who see the music and hear the flowers dance. SABC, sharing 20 years of inspiration.
Welcome back. In an exclusive interview with Chief Justice of South Africa, Honorable Justice Mogoeng, access to justice cannot be overemphasized, and the Transitional Courts Bill, which also is a mechanism for access to justice, will have to master constitutional scrutiny. Mr. Chief Justice, for the dispensing of justice, how important is legal aid?
Legal aid is central to ensuring that the poorest of the poor receive a fair trial. You see, we come from an era when most of the poor, black people in particular, and the vulnerable people, were caused to go through criminal trials without the benefit of legal representation. And now that we are a constitutional democracy, it is crucial that everything possible be done to ensure that those who do not have the means to enlist the services of legal representation are provided with legal representation at state expense. It's not just a constitutional imperative, but it is also a way of ensuring that when we claim as the court system or the broader justice system to be dispensing justice to our people, it is indeed quality justice that they receive. And absent the assistance of a well-qualified and skilled lawyer, we're just going through the motions when we present to these groupings people who are less qualified than they ought to be.
You have lamented the fact that regionally in Africa, the judiciary is not consulted when issues of justice are being discussed by politicians.
It is not just in Africa, it's a worldwide phenomenon, and I believe that until such time that leaders of the judiciary take up the responsibility of ensuring that there is a common understanding about the crucial role that the judiciary has to play and the contribution that they could make in enriching these discussions that impact on the role of the judiciary at a national, regional, continental, and global level, then something good will come out of it when the judiciary, the leadership of the judiciary in particular, is well consulted.
How important, in your view, is this conference, this international conference on legal aid?
It is crucial because you would appreciate that legal representation is a fundamental right. It's central, as I said, to ensuring that trials are fair. Now, for leaders from various countries, and I was led to believe about 70 countries are represented here, to come together and deliberate on how best to ensure that those who do not have the economic muscle to enlist legal representations are assisted by the state. I think it's a very important thing. It's going to help us identify what is it that the different countries can do, even within their limited resources, to ensure that at least the poorest of the poor are assisted whenever they are confronted with legal proceedings. Remember, it is about the risk of people's liberties being compromised at times in circumstances where they are innocent. It is also the risk of people going to jail for long periods than they could otherwise have gone had there been proper legal representation provided for them. So it's a very important thing, because some people go to prison, lose their jobs, and their families go into disarray in circumstances where they shouldn't have been there in the first place had the state owned up to its responsibility of providing legal representation to them. So I'm glad that the conference happens in South Africa, because South Africa has made great strides in ensuring that the indigent people receive quality legal representation.
Recently, we've had the Traditional Courts Bill withdrawn from Parliament, and many people, commentators, said the bill is unconstitutional. You made reference to that, say if it meets constitutional muster, then the traditional courts can be used for access to justice.
Yes, I took a principled decision never to comment on that Traditional Courts Bill. But my position is this. I believe that traditional courts are institutions that have not been given the possibility of demonstrating what good they could bring about in enhancing access to justice, and also in ensuring that the workload of the broader court system is brought down. I believe that if you can restructure traditional courts and empower those who preside in these courts so that they are familiar with the procedures, they are familiar with the Constitution in particular, but more importantly also make sure that traditional courts are constitutionally compliant, those courts could go a long way towards making justice more accessible to our people. They don't have to travel long distances, as I witnessed in Iduja, for instance. Before they could get to the courts, you just mind your business in the early hours of the morning. At the right time, you walk to the traditional courts and participate in the necessary court proceedings. So the operative word, and I don't want to be misunderstood, is ensuring that those courts are constitutionally compliant, but also they require some restructuring and proper resourcing. That way, they will make an immense contribution to our judicial system.
Share your views and comments with us on Twitter at Recourse or hashtag SABC News Online. Stay with us.
Malibongwe igama lamakhosikazi.
Welcome back. The academic institutions of South Africa play an important role in their assistance of the indigent with access to justice. Professor McCoy Mason, Professor of Law at the University of KwaZulu-Natal, shares with us the importance of legal aid to the indigent and the role played by the United Nations Office on Drugs and Crime. How important is legal aid for the indigent?
Legal aid is very important for the indigent and for everybody else, because unless you can judge the living standards of the very poorest people in your community, you cannot really say that you have a community which is a democratic one, which functions under the rule of law and so on, if you've got a lot of poor people who are disaffected by it. So you have to provide them with legal services. Only the rich normally can afford lawyers very often, and there's a huge number of people who can't. So we've got to think creatively of how can we help these people.
You got an accolade from the Chief Justice of the Republic of South Africa for your fight for legal aid for the indigent. Can you give us a background to that accolade?
Well, in 1971, 2001, I was asked to organize a legal aid conference, which we eventually organized in 1973. I didn't know anything about legal aid then. I just joined the law faculty. But we had a very successful conference there. For the first time, I learned about law students providing legal aid services to poor people in law clinics, if you like. After that, the month after the conference, I set up at our university a law clinic. The dean said, as long as it doesn't catch money, do it. So I did that. And then after that, I got more and more interested in legal aid. I've written a lot in legal aid. The old days under apartheid, legal aid started off mainly dealing with civil claims, not criminal claims, mainly dealing with white folks, not the rest of the population. So I kept nudging and pushing. And I spent a lot of time writing on legal aid and trying to bring changes to legal aid. I was very lucky when President Mandela took over. He appointed me to the legal aid board, or Minister Dalla Omar did. And so I've been involved in legal aid over the years. And the South African experience is such a good one. I think it's the best of the developing countries that I've brought legal aid people from 12 different countries now to visit them here. And some of them have looked at our model, and we can learn from them at this conference as well. But legal aid, as the president of Sierra Leone told me, is essential for a democratic country. He says one of the reasons they had a civil war in Sierra Leone was that all the lawyers were sitting in the big city of Freetown. Nobody was out in the country areas. The only time people saw the law was the police and the prosecutors. Nobody protected them when they needed lawyers in court. And so the rebels went and said, guys, support us in the rebellion, we'll give you justice. And that ended up in a civil war. So he's very keen to get legal aid in his country, and I helped them draft their Legal Aid Act a few years ago.
There has been reference to people who cannot afford to pay minimal sums of money for bail in South Africa, and the Chief Justice made reference to that. But we understand that Legal Aid South Africa doesn't pay for bail.
Yes, Legal Aid South Africa doesn't pay for bail, but bail is something now for poorer people in rural areas, for instance. Often the community will get together because bail money, remember, is only a deposit to make sure that you go to court. If you come to court, even if you're found guilty, you will still get your bail money back again. So it's like a surety, really. In some countries, they have people who specialize in bail bonds, in America and so on, which means you can go to a particular person and he will say, okay, I will pay your bond, but you sign an acknowledgement of debt so that you repay me if we don't get that money back, and maybe charge you for that. We don't seem to have that practice in our country.
We seem to have an awful amount of people sitting in jails, awaiting trial. And probably, what can Legal Aid South Africa do in this case?
Well, Legal Aid South Africa do employ paralegals, and paralegals go to the prisons and they talk to awaiting trial prisoners. I would like Legal Aid South Africa to go a little further and do what they do in Malawi, where they send paralegals who go in and they wear a blue thing which says paralegal, so the prison officials know when they're conducting a meeting it's the paralegals. They train people about what happens in the court, what will happen to them. They also, if cases are going to be postponed, they bring the magistrates to the prison and they run the court in the prison. So you don't have to worry about transporting prisoners and getting them back there on time before supper and all those sort of problems. You bring them to the court. They are then prepared by the paralegals. They then will make their case why the case must be postponed. But the other good thing that Malawian paralegals do is they go around and find guys, look, this guy's been awaiting trial for 10 years. If he gets sentenced, he's only going to get 3 years in prison. We should let this guy just plead guilty and get out. And they sort out, they meet with magistrates, prosecutors, and prison officials to get all the guys who get lost in the cracks out of the prisons.
We understand South Africa played a huge role in the United Nations principles, and can you explain that?
Well, some of us, I was involved with the drafting of that and the Lilongwe Declaration before that, but once we had them drafted, we needed to get some countries to take the lead in lobbying for its adoption by the United Nations. And because of our good record in South Africa, I approached here the CEO of our Legal Aid South Africa and suggested, look, one of you guys needs to go and do that. And fortunately, Judge Malambo was selected to do that. He went there, he worked with Georgia, the other country, former part of Russia. Those two countries worked together, they did the lobbying, he chaired the session where he got everybody on board. So South Africa did play a very important role in getting those guidelines and principles adopted.
Professor, I seem to ask this question of everybody. There's a dichotomy here. People say you arrest somebody who has committed a criminal act, and yet you want the state to pay for his defense.
Yes, well, remember the state is the taxpayer, and remember we live in a democracy, and in a democracy everyone's entitled to a fair trial, and a fair trial means equality of arms. If I accuse you of something, I've got all the force of the state. I've got the investigators, the prosecutors, and so on. If you've got nothing, you're going to be, it's like someone bullying you because you've got nothing, right? And you're not going to think the trial is fair because you've got the state up here and you've got these guys down there holding you. So you need somebody to come back and redress the balance. So the price we pay for democracy is to make sure that we have the rule of law and that our citizens are entitled to a fair trial, presumption of innocence. If they can't afford lawyers, they have to be given lawyers. And that is part of our international obligations as well, under the International Convention on Civil and Political Rights.
Professor Philippa Kruger is a clinical legal educator at the Wits Law Clinic. She shares with us the important role played by university law clinics in their fulfillment of access to justice. Professor Kruger, how important is the role played by university law clinics in legal aid?
Well, historically, since 1995, the role became very, very important because legal aid in South Africa was struggling at the time, and law clinics were able to fill a gap in the market and to offer quality legal services to the poor, mostly in civil cases. So even today, they complement the work of Legal Aid South Africa, because the Legal Aid South Africa has to primarily fulfill their mandate of criminal defense, whereas law clinics can assist in civil matters, and they've developed the necessary expertise in these civil matters. And at the same time, they teach law students and instill in law students a sense of social justice that hopefully they'll carry with them into their careers.
Listening to many people around here at this conference, it's also come to my attention that law clinics have done a great deal in shaping Legal Aid South Africa.
Well, I'm not sure about shaping Legal Aid South Africa. You know, in the 1990s, the law clinics were already established and formed a partnership with Legal Aid South Africa, and that formed the basis of the justice centres that then sprung up in the early 2000s, around about 2000, and in fact, I was fortunate enough to spend a year, 2000, working with Judge Mohammed Nafsa in transforming the legal aid.
How important is conferences like this international conference on legal aid that is held in South Africa today?
Well, I mean, it's critical. It's a matter that cannot fall off the agenda. And if you have a look at the principles and guidelines that have been adopted by the United Nations, it specifically states that law clinics have an important role to play in dispensing legal aid. To have people from all over the world to learn from them and to share our experiences, I think is invaluable. And as one of the leading law clinics in South Africa, in 2013, the Wits Law Clinic celebrated its 40th birthday. So we have obviously years and years of experience, both in access to justice and clinical legal education, that we are now keen on sharing globally, but particularly with other countries on the continent.
Share your views and comments with us on Twitter @RightsRecourse or hashtag SABC News Online. Stay with us.